conditional use hearing concerning the Mountain Trail Solar LLC application. And it's my understanding that we're now going to move into the rebuttal phase for the applicant. So I will ask Mr. Gallagher to call his first witness.
Thank you. Pat, are you online?
Mr. Hardy is present on the Zoom. I don't see his picture or there he is. What I'm going to do is I'm going to spotlight him so that everyone is going to be looking at you, Mr. Hardy. Okay. Ms. Fowler, I'm going to unmute you for a moment just so you can confirm that you can hear us, because we are using the microphones.
I have 2 more exhibits from the last time I did not use that.
So you want this movie now?
Yes. Back to 47 and 48.
Sean, you have to, just because we have people on Zoom, please make sure you're using the microphone.
Will do. You just swear.
Sir, please raise your right hand.
And unmute yourself, Mr. Hardy.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Pat, can you verbalize so she can hear?
I do.
Okay, thanks. Can you please state your name for the record?
Yes, my name is Hardy.
And what is your occupation, Mr. Hardy?
I'm a civil engineer that specializes in noise studies.
Okay. Who's your employer?
Emily Warren and Associates.
Okay, I'm sorry. What is your title?
I'm a noise specialist.
What do your duties as a noise specialist include?
On my day-to-day, I manage and maintain a multitude of projects across the firm and the nation, analyzing data, bottling data for various projects, and then obviously reporting and summarizing said data and providing potential recommendations for abatement if need be.
Okay. What is your educational background?
I've got a Bachelor of Science as well as a Master of Science from Clemson University.
Okay. And do you have any certifications?
Yes, I'm a professional engineer registered in the state of North Carolina and South Carolina.
Okay. And are you a member of any professional organizations related to noise?
Yes, I'm part of the AEP 80, committee on transportation-related noise and vibration that's associated with the Transportation Research Board.
I have handed out to the board the board here your CV, which has been identified as Exhibit 49. Does this outline your education and experience?
Yes, it does for solar projects.
Okay. And you prepared this exhibit?
I sure did.
Okay. How many solar projects have you worked on?
In upwards of 50.
Have you ever testified? Well, let me go back. Have you ever done noise studies that are unrelated to solar projects?
Yes, I've done noise studies for transportation-related projects as well as industrial, residential, utility, you name it. I've probably touched it in some way, shape, or form.
How many noise studies do you think that you've conducted?
In upwards of 1,000.
Have you ever testified as an expert witness before?
Yes.
In your capacity as a noise specialist?
Yes.
Was any of this testimony specifically related to solar projects?
Yes, some.
Okay. Have you ever been rejected as an expert?
I have not.
Okay. At this time, I would like to offer Mr. Hardy as an expert in noise analysis related to solar projects.
Okay. Mr. Cluck, do you have any questions with regard to this witness's qualifications?
Yeah, I didn't hear, who was he employed by?
Kinley Horn.
Is there any reason you didn't include that on your CV? I'm sorry, can you hear me without a mic?
I can, barely.
Ted, I just wanted to know why you didn't bother to include that on your CV.
Honestly, I have no response. It just wasn't included.
How long have you worked for Kinley Horn?
I've been employed with the firm for approximately 12 years.
Did you participate in the sound study that was Exhibit 24 in this case?
Yes, I did.
I'm going to object to this. I mean, I don't have any problem with his qualifications, but I don't think it's proper rebuttal because the sound study was in their case in chief. He didn't testify in the case in chief, so I don't see why he could testify on rebuttal.
Okay. Let's stick with the expert issue. I'm going to hold your objection in abeyance, and then I will address it before we get into the substance.
Yeah, no problem with the qualifications.
Okay. Thank you. Mrs. Palanuk? No?
Nuck.
It's been
No
six,
objection.
six months, I'll eventually get it, right?
No, I have no problem with his qualifications.
Okay. Palanuk, okay, I got it. Mr. Hartman, are you here? No questions for Mr. Hartman. Mr. Hoffner is not present. Mrs. Stabile, not present. Mr. and Mrs. Yob,
No problem.
no objection to qualifications. Mr. Osenbach is not present. Mr. Balthaser.
Yes,
Oh, you're back from Florida.
back from Florida. I'm Mrs. Balter.
And Mrs. Balthaser. Any questions for
I
us?
do have some questions.
All right, if you want to come forward and use the microphone just so that he can hear you.
Did you do any of the study that was submitted with the application?
Yes, I did.
Okay. Were you the chief engineer on that study, or was someone else?
In regards to the sound study, I was ahead of the whole thing.
Okay. Who was the chief architect of the study?
Of the study, the noise study?
Yes.
Me.
Okay. Are you licensed professional engineer in Pennsylvania?
I am not.
Okay. Then I guess I'm questioning the validity of the study.
So
Not a
the
Pennsylvania engineer?
so you're objecting to his qualifications?
Yes.
Okay, thank you.
Further questions?
Mrs. Balthaser?
And how many testimonies have you given for solar projects?
2 or 3.
And were they all for Leeward community?
No, they were not.
Okay, that's it.
Thank you.
Thank you.
Ms. Fowler, who is on the Zoom call this evening, do you have any questions with regard to qualifications?
I don't have any questions about his qualifications, but I wanted to ask, I don't have a copy of the CD to review. Is it possible to get a copy?
We could get a copy, but probably not during the hearing. Unfortunately, we don't have the ability to upload anything to the remote site during the hearing.
I understand. I know I was requested to have my exhibits uploaded in advance. I was expecting the same courtesy to have the exhibits in advance for tonight's hearing.
I understand, Ms. Fowler.
That's all I have.
And then does your dad have any questions? Does Mr. Fowler have any questions?
No, I don't have any questions.
Thank you, Mr. Fowler. Okay. So first, Mr. Gallagher, do you have a response to the objection from Mr. Balthaser?
There's no requirement that a noise specialist be an engineer, period, just that they have sufficient training in the area.
Okay. I understand your objection, Mr. Balthaser. I do think that the board will take into consideration the fact that he is not a Pennsylvania licensed engineer. However, I don't think that that fact in and of itself warrants us refusing to accept him as an expert. So he will be admitted as an expert in the field of noise studies, as previously stated. The second issue that we now need to address is Mr. Cluck's objection as being an improper witness for rebuttal. So at this point, Mr. Cluck, do you have an argument in addition to what you stated?
Not particularly. I mean, he should have been on direct examination in their case in chief if he was the prime author of the study. So I don't know why can they now have him as a rebuttal witness? I think that should have been their case in chief, and I don't think it's proper rebuttal. I don't have any cases to cite or provisions in the MPC. I think it's just a matter of litigation.
Mr. Gallagher.
There were a number of questions raised with regard to the study during the objector's case, and more specifically addressing those issues that were raised.
Can you give a more detailed proffer on what he will testify as to?
The study, just generally, and then responding to the comments that were made during the case in chief. The objector's case in chief.
So when you say this study, what are you referring to?
Objector's Exhibit 19 and the testimony that was given with respect to noise.
Just give me a moment to review number 19.
There were also a number of questions. As you may recall, Mr. Hughes testified originally to the noise study, and there were a number of questions on cross-examination that were asked of him as well. So we are responding to the issues that were raised.
And is there a reason that he wasn't called during your case in chief?
We didn't believe it was necessary or required, but after we finished our case, there were other parties who presented testimony and exhibits on this issue, and we're responding to it, as is our right.
The board's gonna go into an executive session to consider the objection. So we will go off the record and we will return shortly. go back on the record. I have conferred with the board on the objection that's been raised by Mr. Cluck. And the objection will be sustained in part and overruled in part. And what I mean by that is that Mr. Hardy will be permitted to testify. However, his testimony is going to be limited to what the purposes of rebuttal is. That means that he can address issues that were raised in the objector's case in chief. He is not permitted to testify as if this is a case in chief, meaning that he is not permitted to present new testimony or new information. He is only permitted to answer questions that will rebut or attempt to rebut the points that were made in the objector's case in chief. And if he strays beyond that, I'm sure Mr. Cluck will readily object so that we can address that. So you may proceed, Mr. Gallagher.
That's fine. We weren't planning on recreating or starting from scratch on this. However, it would be helpful if we had just a couple of background.
Can you speak up, please, or use the microphone a little closer?
So, just for background purposes, just to rehash some of the issues in the study, I don't believe warrants an objection. We're not going to be going into detail in the study, but a little bit of background is required to set up some of these questions.
You may lay your foundation, but understand that you're on a short leash on this.
Understood. I thought we'd be done by now with this witness for what it's worth, but yeah, thanks. Okay, Mr. Hardy, you ready?
Yep, good to go.
So you're familiar with this site, correct?
Yes, I am.
Okay, and you've been to the site?
I have.
Okay. Did you review what has been identified as as Objector's Exhibit 19?
I have.
Okay. And there were a number of comments related to noise.
Yes.
Just for clarity, Objector's Exhibit 19 and Applicant's Exhibit 24 are the same document.
Exhibit 019 is, I believe, Mr. Haig's letter.
Okay, thank you. Yes, that is correct.
Can you please address how many inverters were included in your modeling?
Yes, there were 22 inverters included in the model.
Okay. And did your modeling take into account, well, what was the model that was used?
We use sound plan.
Okay. And is this a commonly accepted method of determining potential sound?
Yes.
Okay. And does the model take into account the terrain?
It does.
Does it take into account ground cover?
It does.
Okay. And just to explain to the board, what were the maximum operational sound levels that were predicted?
Based on the analysis that was run with all the equipment, it was predicted to produce a maximum of approximately 45 decibels at the closest and most sensitive land use.
And your report did not address or evaluate construction noise.
No, it did not.
And why is that?
Because it's exempt from the zoning ordinance.
Okay. And in your experience, is it typical to ever evaluate construction noise?
Periodically, but it is not common.
Okay. So you did review Mr. Haig's testimony that was given on February 26th, correct?
Yes, I did.
The first thing Mr. Haig said, the first thing you have to do in a noise study is to determine the power level. the sound power level of the sources. Do you agree with that?
Not fully, no.
Why is that? Can you explain?
Because the sound power is one method of being able to then determine potential noise levels from an operational piece of equipment. But the methodology that we ended up implementing was using sound pressure levels, which were provided via the some general manufacturer specifications that we had used at the early stages of the analysis. And just for general reference, a sound power level doesn't change with distance. It is what it is, and so the reference of using a sound power level is not incorrect, it's just not the methodology we used. And so think of it in terms of like a light bulb. You have a wattage rating on a light bulb, and that doesn't change no matter what you do to the light bulb. But the further away you get from it, the perceived brightness is going to diminish. And so that's kind of the sound power versus sound pressure. And you can calculate sound power using sound pressure levels. And so regardless of which ones you use, the results of the analysis would have been very, very similar, if not exactly the same.
Okay. And in that letter or Objectors Exhibit 19, there were a number of calculations provided. Did you review those?
Yes, I did.
Okay. And do you agree with those calculations?
Partially. The thing that I guess can come about with the calculations that were performed is that while the formula used is not incorrect, there are multiple pieces of information that our model is able to take into account that formula cannot and does not. And so, we had mentioned the fact that topography, ground cover, like those are a couple pieces of information that the model factors in throughout its calculations, as well as the directivity of sound from the source. And so, once again, while that formula is not incorrect, it's just a very high level check from a noise standpoint versus the more detailed outcome and results that were produced by the model itself.
And just that equation doesn't account for factors that are addressed in the model.
Correct.
And what were some of those factors that are not addressed?
So the elevation changes, so the topography throughout the site, cover, which was assumed to be, what I guess would be designated as soft soils, knowing the agricultural uses out there. And then, like I had also mentioned, the directivity of the source itself, so how the sound is radiating from the inverters and the transformers in this case.
Okay. And did the model analyze all the operational equipment that's proposed for this facility?
It did.
Okay. And in your expert opinion, do you believe that the noise generated from the site will comply with the township's noise regulations?
I do.
I have no further questions.
Thank you. Cross-examination, Mr. Cluck.
Tad, you said 22 inverters?
Yes, sir.
How many skids?
22.
Are you saying an inverter skid is the same as an inverter? Doesn't a skid have a number of inverters on it?
I guess it can. We had looked at the inverter equipment pads as individual sources of noise that may include more than one, but to my knowledge, at the time of the analysis, it was assumed to have one, what we would call big box inverter on top of the equipment pad.
Where can I find that in Exhibit 24, your sound study?
The total quantity?
Yeah.
You can't. It's not listed.
Why not?
It's just not. We looked at it, and you could go and look at the heat map that's provided on page 8 to go back and look and see about how many inverters were included in the model.
You said the model also looked at terrain. Where is that in the report?
We had mentioned that the sound study, you use sound plan. If you look on page 6 of the report under figure 3, it states that sound plan can account for topography, ground cover type, intervening structures, and so those were included.
Well, it says it can account. How do I know it actually did?
I guess you don't, but it did.
So if anybody wanted to replicate your study, that would be impossible based on this document, isn't it?
I guess to an extent.
And isn't good science something that can be replicated?
Mm-hmm.
Same question for ground cover. That's not identical. It says the model can account for ground cover, but you don't actually say anything about ground cover in your report, do you?
No, we do not.
You also said construction noise is exempt. What provision of the zoning ordinance exempts construction noise?
If I have my reference correct, it is section 608.5.c.4.
Did you review applicants' exhibit 39, the health and safety assessment report?
Yes, I did.
Do you disagree with their findings with respect to sound power levels for some of this equipment?
No.
So you don't disagree with Mr. Hayes' report that quotes that assessment report and criticizes your study?
I disagree with the criticism in the sense that we did not use sound power, so it's not a direct comparison to the methodologies that were implemented and included in our analysis.
That's all I have.
Thank you, Mr. Clark. Mrs. Kalanick. You want to come up to the podium?
I have a two-part question. Was the noise study done right across the road from the homes?
When you say noise study, what are you referring to particularly?
The way it was modeled, did you take that information from right across from the homes or just a generalized topography of the area?
I'm having a hard time understanding what you're trying to ask.
Where did the data for where the noise study should be done come from?
The source or something else? I feel like there needs to be a little more clarification for me to understand what you're asking.
So you have to take data of an area, right, to do a noise study? Or do you just take data from the inverters that you use and say, oh, they're only going to produce this amount of noise? Do you actually look at the topography to determine how the noise is going to affect that area?
Yes, the existing topography was utilized to create a SERP purpose within the model that then was overlaid with the operational equipment that was proposed throughout the site and was then modeled as can be seen in figure 4 of the report that we had prepared. And so topography is included in there, which allows for noise to travel over valleys or dissipate as it goes up a hill in whichever direction is necessary for the analysis. And so all of the surrounding residential uses were analyzed and included obviously in the model, and worst case operational noise levels were reported at approximately 45.
So you use those actual very specific land angles, angled terrains, the areas where the homes right next door to this are?
Yes, the entire project area as well as the area outside of the project boundaries were included in the surface of the model to allow for accurate representation of topography throughout the area. And so yeah, that was included well beyond the boundaries of the project.
All right, that's all I have, thank you.
Thank you. Mr. Hartman, no questions. Mr. and Mrs. Young,
No.
no questions. Mr. Balthaser.
Okay, you mentioned that the ground cover was used in your calculations.
Mhm.
Did you use the existing ground cover in topography?
So there's a default ground type of, would be designated as soft-ish. I guess I need to verify the correct reference, but it's designated as somewhat of a soft ground type, which is usually indicative of the type of soils as well as ground cover that's out there, being the agricultural uses that are throughout the project area. And then, yeah, that's the existing topography that is publicly available was used to generate the surface that was implemented in the model.
Okay, so the change in topography that is proposed with the project, that was not taken into consideration.
Excuse me, you're breaking up?
The change in topography when the project is completed from the current topography, that was not included in the study?
No, minimal amounts of grading were anticipated, so detailed grading was not included in the model.
Okay. Now, when you say ground cover, there's vegetative barriers that are going to be established as part of the solar farm. Is that taken into consideration in the sound study at all?
No, we did not include vegetative buffers in the sound study as a conservative measure.
Okay. All right, no further questions.
Thank you. Mrs. Balthaser.
You mentioned 45 decibels. Can you maybe describe to us what 45 decibels would sound like?
Yes, of course. 45 decibels is generally deemed to be relatively quiet. If you were sitting on your couch in your living room and you maybe heard the slight hum of your refrigerator in the kitchen adjacent to you, that's about what you could anticipate or equate 45 decibels to be. And that was also the approximate average of the existing noise that was measured throughout the site as well. So generally, it's anticipated that minimal changes in the existing noise environment would occur once the project is operational.
So you're saying that there was actually testing of the current noise levels? Because typically
Yes.
rural areas are a lot quieter than 45 decibels.
Yeah, based on the measurements that we obtained throughout the project area, we had collected 6 one-hour measurements at various points throughout the day in various locations, some closer to roads, some a lot further away from some roads. And on average, we measured somewhere between 44 decibels and 64 decibels up near the highway to the north of the project.
North of the project, but we're not north of the project.
Well, on the northern project boundary, we measured noise levels up to approximately 65 on the northern portion of the project.
And how many of those data points were on Lyle Road?
We're on what road?
Lyle Road?
I'm not 100% sure where that is exactly located.
I mean, there's a lot of houses on Lyle Road, so I would imagine that concentration should happen on Lyle Road.
Okay, so I will say that the area, the western portion of this project was added in after the field work was completed. So the closest measurements we have over towards Blau were approximately 50 decibels and 55 decibels that were measured in the field.
And where was that? You're saying close to Blau Road, but not on Blau Road.
Not on Blau Road, it was close to it. So one of the measurements was taken east of Sunday Road between Crick Lane and S Road. And then the other one that I referenced was south of Gruber Road and east of Sunday Road. So in proximity to Blau, but not directly adjacent to it.
I think that's definitely a fault in the study. I mean, Blau Road definitely needs to be included in whatever studies that are happening. Blau Road needs to be included.
Well, I want to point out that none of the traffic noise that is generated was included to understand the operational noise levels that would be generated to then determine if any, abatement or mitigation was needed. So traffic noise was not a factor outside of what was measured in the field.
But I'm not talking about the traffic noise. I'm saying when you're on Blau Road and you're talking about this 45 decibel, is that what you think it's going to be on Blau Road, or is that on House Road? I'm not talking about where you got your noise points, which there again, Blau Road should have been included because it's probably quieter than some of the other areas, but of how the houses on Blau Road are going to be affected. Are we going to be listening to 45 decibels? Is that going to be 24/7? Because that is definitely higher than what should be acceptable, especially in the nighttime hours when people are trying to sleep.
Okay, I understand your question better now. So the inverter equipment that was analyzed in proximity to Blau Road is located really far from the residences that are adjacent to that road. And so the loudest noise level that was reported, the 45 decibels, actually occurred closer towards the eastern end of the project near where the substations are located. Klaus Road, Hess Road, south of Gruber. And then the anticipation of 24/7 operation is minimal, if not completely zero, because the fact that the inverter equipment that would be on site does not generate power when there is no sun to convert the energy from. So nighttime noise levels should be almost exactly the same as they are today, given the fact that the equipment that would be on site cannot and does not operate at night.
Should be, but may not be.
May not operate at night.
The other question is, if noise becomes problematic, are there, things that can be put in place to mitigate that noise? Can there be covers put on, or dampers, or something of that sort that would make it quieter? Are there things available today that would make it quieter if it does become a problem, or if it is a problem?
I speak in general terms. The answer is, yes, there are ways to further reduce noise, but based on the measurements that were collected throughout the project area, most of the operational noise is anticipated to basically blend into the background, given the fact that it's not loud, but it's not quiet completely. And so if a problem arose, I'm sure something could be implemented, but that wasn't something we ended up analyzing based on the results that were generated and the levels of compliance that are anticipated.
I live on Blau Road for 28 years, and I can tell you the average noise is birds chirping. Unless somebody's cutting the grass, or if the wind is blowing a certain direction, that we're hearing the traffic. So when you're saying it's going to blend into what we currently have today, I hope that's true. No other questions?
Thank you, Mrs. Balthaser. Ms. Fowler, do you have any questions?
I have no questions, but Scott has some.
Thank you. Mr. Fowler.
All right. The first question I have is about the inverters that you use for the modeling.
Mm-hmm.
Do you have a model or make for those inverters that you used in the model?
I do. we were provided with some information at the initial phases of the project, and we're able to use those as reference points, but the exact specifications weren't, I guess, known at the time as in regards to whether these inverters would or wouldn't be implemented. But what we ended up being, I guess, referred to using in the study, I'm trying to get the exact information you're asking for right now. Power electronics, HEM, and let's see, it was, HEM was the information that we were given. I believe the model number or reference number that was provided was FS3430M, if I recall my notes correctly. And that was the specifications provided estimated noise levels of approximately 79 decibels at 1 meter from the unit.
Do you know the model, make and model of the actual inverters that are going to be used in this project?
I do not. I'm not sure if that information's been decided on yet.
So you're basing the model, you're deriving numbers with this model based on an inverter that may or may not actually be used.
Correct. I will say that the emission levels for the reference inverters that were used are very typical within the industry. So it's not anticipated that a large deviation from what was modeled versus what will be implemented would occur, but that's something that we would want to coordinate on in the future if something changed.
You mentioned you did a lot of modeling for other solar projects. Were any of those projects completed?
No, some of them are in construction or about to start construction, but none have been fully completed and are operational just yet.
So you haven't actually been able to check in the field to verify the model results?
Not yet. We are slated to do that with a handful of projects this year, though.
Now, you use sound pressure modeling? Is that what you said?
So we use SoundPlan, which is a modeling software, and then we used the sound pressure levels that were included in equipment specifications to then generate the modeled noise levels throughout the project area.
Just so I understand this, if you double the pressure of the sound wave that you're hearing, how many dB does the sound level go up?
Since noise is logarithmic in nature, when you add, say, two noise levels that are exactly the same, you generally only see a 2 to 3 decibel increase in noise levels at the most, which in regards to human hearing, it's considered barely perceptible. So it's, 2 to 3 decibels is on average what you would anticipate if you had two noise sources of the exact same operating next to each other.
Does your modeling take into account any kind of reflection that might occur off of a building?
Yes, structures were included that were in close proximity to the project to be able to either shield and or reflect noise, but most of the structures within the vicinity of the project were really far away and did not have any effect on, blockage and or reflection.
If I'm a resident nearby and say I'm sitting on the front porch, I'm going to be hearing the direct sound from an inverter and possibly the reinforced level of the reflected sound off of my siding or wall. So would it be reasonable to say that the level could be 2 to 3 dB higher than the direct signal coming from the inverter?
It depends on your proximity to an inverter. Most of the residential, if not all of the residential properties around this project are far enough away to keep that from happening, or at least to a very, very minimum, to where increases in existing noise levels are anticipated at a very minimal level.
All right, thank you. That's all I have.
Thank you, Mr. Fowler. Mr. Gallagher, do you have any redirect?
Just with respect to your noise study, it is a summary of the model data that was provided. And is this, you said you have done approximately 1,000 studies. Is this typical of the format that you produce your noise studies in?
Yeah, this is probably what I would consider to be a mid-level type of study. We will dive into more detailed analyses if required by local regulations, and then we've also done a good bit of initial regulation research and anticipated operational equipment checks for various projects as well that are a little more high level in nature.
I have no further questions.
Thank you, Mr. Cluck. Any recross? No questions. Mrs. Palanak?
No questions, thank you.
No questions. Mr. Hartman? No questions. Mr. Yab? No questions. Mr. Balthaser, any recross?
Yes, I do.
Want to just step up just so we can hear you.
Okay, I'm looking at page 8 of your study, and you have this study in front of you?
I do.
Okay. On that figure bottom there, the figure at the bottom there, on the property on the right side, there's one inverter there on the extreme left side of the right property there. That seems to be closest to 2 homes there. And it looks like the light green lines are kind of close to the edge of the property there. Are those 2 properties going to experience some extra noise that these other properties are not going to experience? Can you comment on that?
I mean, there's a potential they could experience some minor changes, but based on the measured noise levels that were obtained in that portion of the project, it's anticipated that minimal, noticeable changes would occur because the 2 measurement locations that I had mentioned previously that averaged approximately 50 decibels and 55 decibels during the measurement period were located in that portion of the project area. So it's unlikely that noticeable changes would occur at those properties that are in proximity to that inverter that you've referenced.
Yeah, because those seem to be the closest properties to those noise circles that you have, the decibel levels.
Yeah, and I mean, the only response I would provide to that is the fact that all of those residents are in close proximity to relatively well-traveled roads, at least from my observations that were made in the field.
Okay, no further questions.
Thank you. Mrs. Balthaser?
I do not.
No further questions. Ms. Fowler, do you have any recross?
No questions.
Thank you. Mr. Fowler?
No questions.
Members of the board have questions?
I do. I'm very confused. You talk about modeling and testing the field. All these tests were done behind your desk in front of a computer screen. You were not out in the field, made some kind of noise, and measured those sound levels at the property line. Is that correct?
I'm having trouble hearing you.
When you did these sound studies, did you go out to the site and make noise where these inverters are going to be setting at and have someone stand at the property lines and take noise measurements?
No, that was not part of the work that we were scoped to provide.
So there's no way to take, in effect, the terrain, the ground coverage, trees, anything in the nature, it's all modeling is what you're doing here.
Correct. We took some baseline measurements to understand existing noise levels that were occurring throughout the project area, and then took reference noise levels from manufacturer specifications and included it in a detailed model that included the terrain, ground cover, and other features like that.
Okay, so I'm not an expert in sound, but I will tell you I live approximately 1.5 miles south of Route 78. Sometimes during the day I hear no traffic at all on 78. There's times during the day I can hear traffic. Does that have to do with the pressure and that you talked about earlier on?
No, that what you're experiencing occurs on a day-to-day basis, and is basically influenced by weather and other factors like that. So the atmospheric conditions are contributing to the noise that you do and don't hear sometimes, even though you're at the same location. And so that fluctuates throughout the day, throughout the seasons of the year. So there's some influence that would potentially occur because of that, but given the emission levels, it's minimal at best.
So you do acknowledge that there's changes in sound based on environmental conditions, not wind, just pressure, inversions, all kinds of environmental factors cause the sound at a particular location to change, even though the source is not changing.
Yes, yeah, the atmospheric conditions play into how noise can travel, and we use I guess what would be considered average baseline conditions in the model. So temperature, humidity, that is actually factored in. It's an average, so it doesn't change within the model.
So these inverters would be the same thing. At some times of the day, they would be at 45 decibels, and other times of the day, based on weather conditions, the sound level is going to be higher at the property lines. Just based on my observation for being 1.5 miles south of 78, which is a major highway.
Potentially, but the noise emissions are quite different from an inverter versus traffic noise from a major highway.
How so?
I mean, it's very, very different in the sense that you've got varying frequencies that come into play with exhaust and engine and tire, noise with the roadway and vehicle types and everything like that versus a single inverter. And so there are a lot of factors at play that you're trying to, I guess, hint at.
But you do acknowledge the sound levels are going to change at the property line based on weather.
I acknowledge that it's possible, yes.
Okay, that's all I have.
All right. Mr. Long, do you have any questions? Okay. This witness can be excused. Mr. Gallagher, is your next witness here?
He just walked in the door.
Why don't we take a 5-minute recess just so he can get himself settled for his 8-hour trek from Milwaukee. You remain under oath, sir, from your prior testimony.
Understood.
So, Mr. Larios, were you present on February 26th, the conditional use hearing here?
Yes, I was.
And that's when objectors, engineer Mr. Haig testified.
Right.
Okay. And okay. And you reviewed what has been identified as Exhibit 019.
Yes, I have.
Which is Mr. Haig's letter. And there were a number of representations made in that letter with respect to the transformer height and generally that a transformer is approximately 20 feet for a substation.
For a project of this magnitude, correct?
Yes, okay. Generally, would you agree with that proposition?
Yes, I do.
Okay. And has Leeward ever represented that items that are going to be located in the substation switchyard are going to be 20 feet or less?
No, we have not.
Okay. And what has been the representation made to the township?
I believe in one of the response letters to Great Valley Consultant question, which I believe the response letter is also on the record, we have stated that the equipment will be less than 20 feet except for the substations.
Okay. And but it'll be approximately 20 feet the transformer.
Correct, yes.
Okay. And there was also testimony from Mr. Hay that the National Electrical Code has spacing requirements.
That is correct. His testimony is correct insofar as the statement he made regarding the fact that National Electric Code has height requirements for the conductors that transport the energy from the transformer towards the utility switchyard across support structures, yes.
Okay. And there will be it has to connect to the transmission lines in the right of way, correct?
Correct. Ultimately, the cables will go from the project substation to the utility substation / switchyard to the existing transmission line.
Okay. And those poles will typically, they'll be approximately the same height as the utility poles in the right of way?
That's correct.
Okay. And I believe that the zoning ordinance also requires that the solar facility comply with the requirements of the National Electrical Code.
As far as I read it, that is correct.
Okay. So I have a couple questions regarding agricultural preservation. The Frederick parcel is currently located in an agricultural security area, but the Gasperry parcel is not.
That's correct.
Okay. And the inclusion in an ag security area requires the owner of the property to file a petition with the township. This is a prerequisite for farmland conservation easement. Leeward is purchasing the Gasperry property, correct?
That is the plan, correct.
Okay. Is Leeward willing to petition the township to include the Gasperry property in an ag security area?
Correct. Yes, we could also propose that the security area be established after the project has been decommissioned and removed.
Okay, so as a condition to approval, would Leeward commit to making best efforts to apply for a farmland conservation easement from the Berks County Agricultural Board after the facility has been removed?
Yes.
As a condition to approval, would Leeward enter into a private conservation easement or a declaration of restrictions and covenants with the township granting the power to enforce those provisions?
Yes.
At the last hearing, with respect to the fire department, when you testified in December, you were asked if you had any discussions with the Virginville Fire Department. Do you recall that?
Correct. At that moment, I had not.
Okay. And after that hearing, did you reach out to the Virginville Fire Department?
Yes, I spoke with the Virginville Fire Chief a couple of times. We scheduled a Zoom meeting where I invited our subject matter experts in civil engineering, health and safety. We agreed on a time and date. The fire chief could not attend the first meeting. He apologized afterwards. He noted he was very ill. He then provided me with additional dates where he could be, time and dates where he could be available. I then sent him an invite for one of those dates, followed up with a couple of emails asking if he would attend. Again, my team attended that second meeting. He did not show up. Afterwards, I left another message trying to reschedule the call, but I just never heard back from him after that.
Okay, but you have been diligent in trying to...
I believe I have, yes, sir.
Okay. At the last hearing, Chief Ames testified, and you've had discussions with him.
Correct, yes, I have had multiple discussions with Chief Ames.
Okay, and he testified at the last hearing that he believed that there was additional training that the fire department needed, as well as equipment. Did you have any discussions with him regarding those, or an agreement as to how to go about that?
Correct. We agreed that we would continue working as if the project evolved. We agreed to provide that training that he needed, and then we also agreed to make a significant contribution towards the 4x4 vehicle that he noted was needed.
And it was understood that you would work together with respect to the development of emergency response plan.
That is correct, yes.
Okay. Do you believe that those would all be appropriate conditions to approval should this be approved?
Correct, yes.
Okay. When you testified in December, we were asked to provide an economic impact study. Do you recall that?
Yes, I was.
Okay. I guess this would be 50.
We'll go off the record for the purposes of marking an exhibit. Torture is not permitted.
Can you identify what's been marked as Exhibit 50?
I'm going to object to any testimony. This is for the case in chief. This is not a purpose of rebuttal.
I agree.
Did you get all that, Jim? Okay. Do you have a response?
We were asked to provide it. I was just asking, this is what Mr. Clark requested that we provide.
I believe he requested it 3 months ago.
We provided it 3 months ago.
So, Mr. Clark, do you have any objection to the exhibit being admitted as part of the record?
This is not Mr. Loomis. So I don't know how this witness can testify to this document.
We weren't planning on providing testimony. I believe the transcript states that we weren't planning on providing any testimony, but we were directed to provide this study.
Right, so this study has been marked as applicant exhibit number 50, and it is economic impact analysis of Mountain Trail Solar Project. Are you just seeking to identify it for the record?
We were asked to provide it as part of this proceeding, and we're just complying with what we were asked to do.
Okay, so then the board will consider it make it part of the record, but to the extent that there was going to be any testimony on it tonight, that objection is sustained.
We weren't planning on it, so.
Okay.
I would object to it being part of the record because I was anticipating proposed findings that the applicant's going to cite this document. It shouldn't be part of the record at all.
The difficulty, Mr. Clark, is that you insisted on this being produced.
When I had an opportunity to examine someone, but they can't produce it on rebuttal. And it's the same thing with the Great Valley comment letter that this witness referred to. That's not in the record.
So, Mr. Gallagher, I think Mr. Clark raises a good point, is that you're producing this document, but you're producing it at a time when there isn't a witness available to testify as to its veracity.
So I know that we've had a number of hearings, and just to summarize the position at the December 6th hearing, I said that we were not going to provide this, that we didn't intend to present any testimony, and we were told, given the direction, to provide this study. We emailed it immediately afterwards, and it's just sat there. We just were trying to finish up, tie up all of the loose ends. So this was something that was asked for us, and we're just complying with what we were asked to do.
You were directed on December 6th to produce it. It is April 3rd. What is the reason that it took from December 6th to April 3rd to produce this document?
We emailed it to you and Mr. Cluck in January.
But why are you bringing it in to be made an exhibit this evening?
Okay, so we finished our case, and he was the last witness that we had for our case in chief. And we were asked to provide this study, which we did. The objectors just finished our case. It seemed like the appropriate time to provide it. I don't understand what the issue is, because we were asked to provide this, we provided it.
Mr. Clark, have you had an opportunity to review this study?
No,
Did you receive this study by email?
probably did, but I don't review things unless I know it's going to be part of the hearing. I'm not going to waste my client's money.
Mrs. Palanak, do you have, was that right? No?
Yes, you did, you did
Okay.
fine.
Do you have a position on this?
Oh, I have all kinds of positions, but nothing I'm going to say publicly.
Mr. Hartman, do you have a position you are willing to share publicly?
Yes. I don't understand this, that he can present this now, that's it. Because, you know, they had, how many times they could have presented it? Now they're on rebuttal, and now new information comes up. I don't understand that at all. I don't understand the spider truck. I don't understand it. It doesn't sound right. So you guys are the experts.
Thank you, Mr. Hartman. Mr. Yao.
Same thing, that everything's always being brought in at the last minute, and then he's expected to work on it in 5 seconds.
Mr. Balthaser.
It should have been brought up as their case.
Mrs. Balthaser.
I agree with Mr. Clark.
Ms. Fowler and Mr. Fowler, do either of you have comments?
I'm against this. I wasn't given the study to review in advance, so I would say no. Mr. Fowler?
I have an objection. It appears that this is being offered as evidence as part of the rebuttal.
Any questions from members of the board?
I do. Not exactly about the admissibility. Can I speak to other issues here? So I'm very confused about this concept about ag security area. What that has to do with what you're saying. Can you back up and help me understand?
I'm going to put a pin on that for 1 second, Mr. Davis, just so we can address this issue. Mr. Cluck, is this something you would like an opportunity to review?
If it is part of the record, I'd like an opportunity to review and potentially have my own witness in a serve rebuttal case, if that's the right term.
Mr. Gallagher, if you're intending to have this made part of the record, then I don't believe I have any choice but to grant Mr. Cluck's request.
Understood. I know that there have been a lot of hearings. I guess this falls in the bucket of no good deed goes unpunished. We didn't want to present this, if you recall, if anybody can recall. So we're not just thrusting this on anybody right now. We said we didn't need to provide this. He went a little bit off the rails, or epileptic, I'm sorry. He made quite a commotion when Mr. Larios was testifying before. He requested that we provide this. I made an argument that we didn't need to provide it. It was completely irrelevant, and we were asked to provide this. So we provided it months ago. I just want to make sure, as we're closing up our arguments in our case, that there's no issue we don't care. You asked for this, we're providing. That's the extent of our offer.
Okay. So it has been marked as an exhibit. The board will not make a ruling this evening on its admissibility, and all the parties are directed to the extent that they wish to review this exhibit. For those of you who are not physically present, we will make sure that this is up on the shared drive for review, and then this will be addressed at the beginning of the next hearing to determine whether or not it's going to be admitted and made a part of the record. And Mr. Club, to the extent that you feel that you need to call a witness on Sir Appeal or Sir Rebuttal, that will be granted.
Don't they have to authenticate the document with a witness? If they can't do that, it's not admissible.
Well, you are correct. However, you objected before he was given an opportunity to attempt to authenticate it.
Well, but Mr. Loomis isn't here.
He's not. I don't think that Mr. Loomis's presence is required to authenticate the document. So I'm willing to allow him to proceed for the purposes of authenticating the document, and then we can see if he is able to do that.
That's fine.
So you may proceed, Mr. Gallagher.
Thank you. What has been identified as Exhibit 50? This was, can you identify what it is?
It's an economic impact analysis of the Mountain Trail Solar Project.
Okay, and this was quoted in the zoning narrative that was submitted with the conditional use application.
Correct, it was.
Okay, and you were asked a number of questions by Mr. Cluck with respect to that narrative.
Yes, I was.
That included this economic impact study. Questions regarding this economic impact study?
Correct, yes.
Okay. And you were asked to provide a copy of it at that hearing?
Yes.
Okay, and this is a copy of what this board asked you to provide?
Correct.
Okay. I have no further questions with respect to that.
Okay, the board is going to go into executive session for a brief moment to address that issue. We'll be back in about 5 minutes.
Before you do that, because you may have to do it for this one, I was going to do this on cross, but the witness testified about the transformer height and the 20-foot, and he made a reference to Great Valley Consultants' response letter. What response letter are we talking about? If it's what I think it is, it ain't in the record.
I'm going to have you hold that for cross.
Okay, I was going to give you a chance to talk about it.
I appreciate it, but I'm going to have you hold it. I'm not going to have him answer it now.
Got it.
Your phone doesn't turn on very fast. Your phone doesn't turn on very fast. Mine's like a minute now.
Okay, we're going to go back on the record. So you remain under oath. Mr. Gallagher, if you want to continue your direct examination.
I forget where I left off. The economic impact study. I think we can move past that. One of the last issues I just wanted to discuss with you, there have been a number of comments. Well, there was a buffering plan that was submitted during your testimony, I believe, last time, correct?
Correct.
And the project is providing additional buffers and screening beyond the minimums provided for. So you can only provide buffering and screening on property that is under your control.
That's correct.
A number of residents have complained or have concerns about their views from their properties. Would Leeward be willing to work with neighboring property owners to provide additional buffering and screening off-site?
Correct, yes, we're willing to work with adjacent property owners in order to provide them with.
If they desired.
Correct.
And this would be, would you propose this as a condition to approval?
I would, yes.
And what would you be willing to do?
So we propose to work with adjacent property owners and then other owners that could be affected by glare in order for them to procure and install vegetative screening, and we would refund up to $5,000.
And this is not just, I mean, this isn't for glare, this is just for view shed.
Correct, yes, sir.
Okay. I have no further questions.
Just for clarification, is that $5,000 per property?
Per neighbor, correct. Per property.
Thank you. Okay. Mr. Cluck, cross-examination.
Horatio, remind me, which company do you work for?
I work for Leeward Renewable Energy.
And does Leeward have any interest in a facility in, I believe it's Drano, Texas?
I do not know, sir.
I'm assuming you keep up on news within the industry?
Jack, this is outside the scope of this testimony.
It's cross-examination. I will allow it to a certain extent, overruled.
I keep up with items that are related to my roles and responsibilities.
And are you aware of a hailstorm in Texas that damaged thousands of solar panels?
I am not, sir.
So the storm that happened March 25th that significantly damaged thousands of solar panels that leached toxic chemicals into the ground. Reading from the Newsweek article.
If you're going to reference that, do you want to make it an exhibit?
It's on my computer. I can print it and
Again, this is outside the scope of his rebuttal testimony.
How do you respond to that, Mr. Cluck?
I just want to know if he's aware that baseball-sized hail damaged solar panels that caused them to leach into the ground. Isn't that something you would want to know as part of your industry? Because your witnesses have testified that there is no basis for harm.
The objection is overruled. Please proceed, Mr. Cluck.
That's my question, if you couldn't hear it. I said, wouldn't you want to know, as somebody with one of the leading solar companies in the...
So that's sustained. If you want to rephrase your question, Mr. Cluck.
Are you aware of the incident in Texas where baseball-sized hail damaged thousands of solar panels?
I'm not aware, sir.
Your objection has already been overruled, Mr. Gallagher, but as noted for the record. Okay, Mr. Cluck, I think that's sufficient.
That's fine. That's okay. I know I would want to know. Okay, let's talk about the height. Would you refresh my recollection on your direct examination that you said certain equipment would exceed the 20-foot height limitation in the zoning ordinance? Did I hear that correctly?
Ask the question again, please.
Would you refresh my recollection on your direct examination that you said certain equipment would exceed the 20-foot height limitation in the zoning ordinance?
No, that's not what I said.
Okay. Help me out. I'm not sure I heard you properly. What did you say?
I said that as Mr. Haig testified, I agreed that there would be structures that are needed in order to comply with safety requirements, safe distance to the cables, and those structures would need to be 20 feet, higher than 20 feet, yes.
What about the substation?
That's in the substation.
So is the substation going to be higher than 20 feet?
There will be structures that are needed for safety purposes, for code compliance, that will be support structures that will be taller than 20 feet.
And did you reference the Great Valley Consultants comment letter?
I referenced a response letter to Great Valley Consultants letter from March 2023.
Okay. Great Valley Consultants comment letter from March of 2023.
To be more specific, or perhaps to clarify, correct, I referenced Exhibit 17.
Thank you. Let me read you response 6a of Exhibit 17. The comment 6a says the proposed use of a commercial solar energy system is subject to the supplemental use requirements of Section 615. The following comments pertain to these requirements. A, the applicant will need to demonstrate that no part of the ground-mounted solar energy system and its support structures exceed 20 feet in height, citing Section 615, parentheses, little e, parentheses closed. The response, comment acknowledged. Please see Detail 2 on sheet C-150 of the conditional use plans for solar panel structure schematic. Panels and supportive structures, including inverters, shall not be greater than 20 feet in height. The proposed substation and switching yard will be taller than 20 feet, as is typical for a utility substation or switch yard. However, proposed structures will not exceed the height of the existing transmission line poles that already exist on site. Is that consistent with your testimony?
I believe that's a paraphrase of what I just said.
Will you be seeking a waiver from the 20-foot height limitation on substations?
I believe that the ordinance requires us to comply with the National Electric Code, and we intend to comply with the National Electric Code.
And you're not going to comply with the zoning ordinance, are you?
Objection,
Will you comply with 615 little e, the 20-foot height limitation on substations?
I think we will need to take a look at which part of the ordinance overrides.
Just to note on the record, Mr. Gallagher raised an objection. That objection is sustained, but Mr. Cluck has already rephrased the question, but I just want the record to be clear.
Do you have a legal opinion on the applicability of the NEC versus the zoning ordinance?
objection.
The objection is sustained. I don't think he has the ability to make a legal analysis.
I asked if he had a legal opinion. I didn't ask what it was.
The objection is sustained.
With respect to do I understand that you have proposed a condition for approval that would include the, putting the, is it the Gaspari mushroom property into the agricultural security area? Did I understand that to be the right property?
We said we would start there and make best efforts to apply to Berks County Farm Preservation Easement after the project has been decommissioned and removed.
Okay, I didn't hear that on the record. After the project is decommissioned, you will then request in 40 or 50 years that Berks County's Agricultural Preservation Board consider putting the Gaspari mushroom property into the agricultural security area. Is that accurate?
That's correct. We also are, as a proposed order condition, are willing to enter into a declaration of restrictions and covenants with the township, where after the decommissioning and removal of the project, the land would be, land use would be restricted to solely agricultural.
Isn't that already required under the decommissioning plan? That you're going to revert the property to its original intended use?
You not hearing what I said correctly. Please ask your question again.
I'm not sure where we're having a little difficulty in communicating. The law requires, after decommissioning, that you revert the property to its original use. Do you agree with that?
We will follow the ordinance and revert the property to its original state.
What was its original state?
Farming.
And what are you proposing to change after decommissioning with respect to the use of the property?
I'm proposing that as a condition of approval, that the project enter into a declaration of restrictions and covenants whereby after decommissioning and removal of the project, the land would be restricted to agricultural use only.
Have you done that anywhere else?
I personally have not.
Has your company done it anywhere else?
I don't know for sure, sir.
Why are you proposing that tonight?
Because folks had a lot of trouble around the change in use from environmental perspectives and from other perspectives.
Wasn't there concern the placement of the solar panels on the farms as opposed to the post-decommission use?
So this would go towards addressing that and ensuring that after the solar farm is removed, that the property will be restricted to agricultural use only.
Have you offered money to any of the other neighbors?
And what, no, sir.
Your company has not approached any of the neighbors surrounding the solar plant and offered them money?
We initially speak with neighbors who could potentially be interested in participating in the project in order for us to either lease or purchase a property for the purposes of developing a solar facility.
Did you approach anyone and request they enter into a good neighbor agreement where they would not oppose the project in return for receiving compensation?
I did not.
Did your company?
I'm not aware of it.
If that occurred, wouldn't you want to know about it?
It would be good to know.
The $5,000 you offered tonight for neighbors adjacent to the project who would like additional buffering, what's the basis for the $5,000 number?
In order to address potential concerns associated with glare or view shed.
I'm sorry, you said glare?
Correct.
How'd you come up with that figure?
Figured it was a fair sum.
A fair sum. Was it based on any study or any analysis of what type of buffering would be necessary to protect the neighboring property from the glare and, as Mr. Gallagher said, and the view?
No.
Would you be willing to go to $20,000?
Not at this point.
That's all I have.
Thank you. Mrs. Helena.
Do you anticipate being in active ownership of this property or this project at the end of its useful life?
Could you please help me understand what you mean by inactive ownership?
Would, whether it is Leeward or Mountain Solar, I'm not sure which entity we're talking about here, they are going to be the owners, basically, of this solar project. Do you anticipate remaining owners of this solar project to the end of its active life, say in 30 to 50 years?
The Leeward is a developer, owner, and manager of the construction process of solar facilities. Our business model is based around long-term ownership, but there's nothing that is certain regarding the long-term ownership.
So that does not make you legally bound to remain to the end of the project?
The legal covenants and restrictions that are or would be applied to the project would remain with the project.
I'm not sure what that means.
That means that the project will be bound by permit requirements, codes, regulations, etc. And so all of those requirements would remain with whoever owns the project.
Meaning you could actually sell this project to someone else if it doesn't work out financially the way you would hope?
I would say that I don't agree with your full statement. However, there could be a chance that the project is sold to another entity.
Does your company do that on occasion? Have they done that?
On occasion, we have, yes.
Okay, that's all I needed. Thank you.
Thank you. Mr. Hartman.
You bet. This farm you're purchasing, you're saying it's not in active security right now, any of it. Are you 100% sure of that?
I believe what we said was that the Frederick parcels are in the agricultural security area, and I believe that the Gasperi parcels are not in it yet.
None of them. You're 100% sure about that?
It seems that
Because I think
I answered your question, sir. I'm sorry. I
Go ahead.
said I believe that the Gasperi parcels, which are being considered for the project, are not in an agricultural security area just yet.
And you're telling me 50 years from now or whatever, you want to put it back into ag security? Or what are you saying there? You want to sell off the development of rights, is what you're saying. Is that what you're saying?
What I am saying is that at the end of the project, we would be willing to accept an order point associated with the permit whereby that Gasparity parcel associated with the project would be restricted to agricultural only after the project gets decommissioned and removed.
No development of rights, so no.
Could you please define developmental rights?
Well, that means we wouldn't be selling it for housing.
That is what we are proposing, is that the project parcel that we're discussing be entered into an agricultural restriction through the instrument that I just defined earlier.
I still don't think that it would not be in that security area now, because if the mushroom company would make any mistakes, they'd be in all kinds of trouble. Whereas if they would be, they'd be covered. That doesn't make sense to me, it's probably not right. Now, if I have a four-wheel drive vehicle, you said you paid a portion of it. What percentage are you paying?
We need to finalize our understanding of the specifications and costs of the vehicle. And we have mentioned this to the fire chief, and we need to continue working on what the requirements are prior to us finalizing on a contribution amount.
According to the fire chief, they'd be buying this vehicle for you people because they already have one, I guess, but they need more because of your large project. Why would you not finance that whole vehicle?
The conversations that I had with the fire chief revolved around the fact that this vehicle could also be used to address and respond within the community. And so we are willing to continue working with them to make sure that we have finalized the response plan, emergency plan, and that we get to a place where we have fully spec'd out what the vehicle needs to have and to be before committing to a sum.
Well, then I don't think the township should pay any of it towards the vehicle because we may not need that vehicle if it wouldn't be for you people. And if you can't commit an amount, say 10%, 50% or something, then to me, I have to take that as 1% because you are not committing anything. And that's what I think everyone else should do. That's it.
Thank you, Mr. Harmon. Mr. Yob?
Yeah, I've got a question about these buffers that you're gonna pay us $5,000 for. Can you erect a buffer, I don't know whether it's agricultural or mechanical, that's perhaps 200 foot long and 80+ foot high for $5,000?
No.
Well, you're not gonna stop the glare or the ugly view from either Peter's house or mine. So. So how's $5,000 get out?
Check just this argument of
Objection is sustained, but your point is made, Mr. Yob. Do you have any other questions? Mr. Baldwin.
Drive the fire truck.
Who's going to drive a fire truck to buy?
Well,
They have the bond.
I'm sorry, you're represented by counsel. So,
Who's it?
I'm sorry, Mr. Young, did you have additional questions?
Yeah, who's going to drive the fire truck?
Members of the fire department.
We're already short on members. Can't get people to volunteer.
Is that a question?
It's a fact that the fire chief said it.
No, I heard Mr. Eames say it, But I'm asking if Mr. Yap has a question for the witness.
I guess not.
Mr. Balthaser.
I do not have any questions.
Mrs. Balthaser.
I do.
You looked a little surprised that Mr. Balthaser didn't have questions.
Do you know that this Safari property is zoned next, since you said it's not currently agricultural?
I did not say that. I said that it's not in a agricultural security area.
Okay, I guess I don't understand what that is then. I'm assuming, so agriculture is different than agricultural security. Can you explain the difference?
The agricultural security area, as far as I understand it, is a prerequisite for us to apply, for folks to apply for a conservation easement before Berks County.
So you're saying what to be conserved as farmland in the end, is that what you mean? Because I'm confused as to what that is.
Can you speak louder, please?
I said, I guess I'm confused as to what that is. I'm thinking he's saying back to agricultural land, but that's not what he's talking about. He's talking about agricultural security, which is obviously different. I don't know what the difference is. As long as everybody else knows what it is, and, okay. Because I guess my question is, and I understand as far as what the zoning says, but if in 50 years, you're still, it's still a viable project, why would you, I mean, the land is already destroyed, it's already full of solar panels, and it's viable, it's still viable in 40, 50 years. Why would you not then at that point say, hey, because you know what, by that point, everybody's already used to, the landscape. People, because I'm not gonna be here in 50 years, probably most people in this room aren't gonna be here in 50 years. But those people that are now purchasing our properties are used to seeing the solar panels. So why in 50 years, when the project is still viable, would you not say, hey, let's continue on with this project? Rather than say, well, now we're gonna get rid of everything and try to make it, back to farmland.
Just one, before you answer, there was an objection from
Oh, I'm
Mr.
sorry,
Gallagher.
I didn't hear you.
It's okay.
It was argumentative, it was generally the characterization of destroying
That portion of the question will be stricken from the record. So the objection to that is sustained, but you can answer the question.
We are stating that we are willing to, we're proposing a condition to the approval of the project whereby at the end of the operation of the project, decommissioning and removal, that the land will be entered into a agricultural preservation easement, either through an instrument with Berks County or through the township.
So, in the duration of the project, I would imagine technology was going to be changing. Obviously, technology changes all the time. So, through its life, as new technology comes about and things become, the solar panel that maybe now is generating, I don't know, X amount of power, and now something comes up that can, the same size panel can generate 3 times the energy. As time goes on, will some of these panels get changed, or will it just, this is what you're putting in, unless it's damaged, this is what's staying?
If that were to be the case, I believe that there would be there is a possibility for that to occur.
That there could be some changes and upgrades as we go on.
Yes.
And back to the $5,000. So, a lot, I'm pretty sure most of us have bought where we bought. Bought because of the openness of the land, the views. So your company is proposing now to give us $5,000 so that we can wall ourselves in so that we are not seeing any views, because now if we're putting trees on our properties and we're surrounding ourselves, so we don't see the solar field across the street or behind us or next to us, we're not seeing anything. So you're proposing to pay us $5,000, which sounds commendable, but to wall ourselves in, which definitely does not also mitigate problems for people driving down the street and being hit with glare, or people walking or biking.
This is both, is you have to ask one question and let them answer, and then ask the next questions.
I'm not an attorney, sorry. But that's what you're saying, when the $5,000 is to plant shrubs or whatever it is, up to $5,000 on our properties to block your view.
Only if you desire.
But, so would that money though be better spent putting more greenery and higher, more trees or whatever on your side to hide the view rather than spend the money to wall itself?
That is something that, ask the question again, please.
Okay, say for instance, you want to give me $5,000, and I say to you, after you guys have done landscaping, can I say to you, take my $5,000 and plant the trees, but I want to plant it on your side of the road to block, so that you have more trees there blocking there versus on my property? Is that possible? Okay, it's something, food for thought. I don't, question, I guess I say a question.
We'll take that under advisement.
Thank you. That's all.
Thank you. Ms. Fowler and Mr. Fowler, do you have questions for this witness?
Yes, I have a couple of questions. My first question was, you mentioned that someone was purchasing Gaspari's land. Could you repeat who that would be?
Yes, that is the Mountain Trail Solar Project.
Could you be specific and name the legal entity that would be purchasing it?
Mountain Trail Solar, LLC.
Okay, and then my second question is, who's on the land option contract for the Gaspari property?
Could you please specify, further clarify?
In the application that was submitted, in the narrative, there was the memorandum of option contract for Gaspari and the Frederick parcels. I wanted to know who was specified on that, like the owner.
Seems like you have the document in front of you.
Could you say that again, please?
Seems like you have the document in front of you.
I'd like you to verify who's on that document.
Does that have an exhibit number?
I believe it's board exhibit 1, the attachment, which was at the bottom of the Dropbox.
I mean, just to help make this along, if you recall, the option agreements, the lease agreements were with Leeward Renewable, and then there were a number of objections that were made that it wasn't for Mountain Trail Solar, and we amended the application to make Leeward and Mountain Trail co-applicants. That request was approved by this board, and we also submitted an assignment from Leeward to Mountain Trail. I don't have that exhibit number, but I know they are exhibits.
That's my recollection as well.
Okay, regarding the assignment of contracts, do you have a legal version of that document? One that's notarized by both parties?
I believe it was, the document was entered into the record.
It was, I know.
The document that was entered into the record is only notarized by one party. It wasn't notarized by the other party.
Correct, we already went over this.
All right, moving question. Has Leeward Renewable Energy or Leeward Renewable Energy Development LLC ever decommissioned a solar project and put the land back to the original state?
I do not believe we have yet, no.
Okay. And my last question is, what is your position with the project? Are you with Mountain Trail Solar? Are you with Leeward Renewable Energy Development? Or are you with Leeward Renewable Energy LLC?
I am an employee of Leeward Renewable Energy Development LLC.
Okay. And what's the relationship between Leeward Renewable Energy Development LLC and Mountain Trail Solar and Leeward Renewable Energy LLC?
Overruled. You may answer the question.
Mountain Trail Solar is a wholly owned subsidiary of Leeward Renewable Energy.
And how is Leeward Renewable Energy Development regulated? The LLC.
I am not a corporate affairs expert. They are related, but I don't know exactly. If you're asking me to trace and or cite the contracts and or the relationship that exists between the two, then I'm sorry, I cannot answer that.
Okay, that's all I had. And Scott has no questions.
Thank you. Members of the board have questions?
Yes, to follow up on that question, it's my understanding, early in this process, it was agreed upon by the applicant and the solicitor that Leeward Energy and Mountain Trail Solar are co-applicants in this process.
Correct, and in addition to that, the option contracts were assigned from Leeward Renewable Energy to Mountain Trail Solar.
So from a standpoint of what the concern I hear in the room, if this project went bankrupt, Leeward Energy is also on the hook for those debts because they're co-applicants. It's not a shell company on the side.
The project company is Mountain Trail Solar LLC. With regards to who's on the hook in that scenario is beyond my level of expertise, sir.
So who can I talk to that has the expertise? What capacity are you in this organization? Are you the janitor or are you the project manager? Who are you?
I am not the janitor, sir. I am the project manager. That's
Okay.
probably a fair description.
Okay, so who would, so you should know that, correct?
I have many responsibilities. I manage permitting, engineering. There's things that we have a whole host of subject matter experts.
So is that something you can come back to us with then, the answer to that question? Somebody on your team that can answer that question?
There's somebody on my team who could answer
Okay,
that
so
question.
can you make a note that we get this information? for
What
the record?
information do you want?
Well, it's fuzzy to the board here about the relationship between the LLC and the owner of Leeward Energy. That's what's fuzzy.
I mean, we spent a whole hearing on this. I don't know that it's fuzzy to the board. Mountain Trail's a wholly owned subsidiary company of Leeward Energy.
Has any documents after that decision been made stated Leeward Energy, Mountain Trail Solar, co-applicants? We decided that at the hearing, but everything afterwards, we only talk about Mountain Trail Solar. We have not married the two together.
I believe they had been married together. I know that, I'm not sure what hearing number this is, 15, somewhere 13, 14, I don't know. Right, exactly. And a lot of it, I mean, I think some has been forgotten, but it's all on the record.
Okay, so it's agreed upon as one organization. It's
For purposes of what you're asking, yes,
Okay,
it's one
thank you.
organization.
Okay, that's what I was unclear on.
Okay.
Thank you. My next question is, if the board decides to approve this here in the next we can get this wrapped up anytime soon, all right? And construction starts. We know what the topography of the land is. There's valleys, there's hills. We talked about 15, 20, there's a lot of land on both properties are in the 15% slope area. You acknowledge that?
Correct.
Okay, so the land out there right now has been farmed under conservation practices, no-till for the most part, and there's been various people here express the erodibility of the soil. So when you go out there, it's been fuzzy to me about what the first steps are. You're gonna go out there and drive a post in the ground to put the panels on. Is there gonna be any, other than the construction from land development requirements for water retention ponds for runoff water, other than that, is the landscape going to be changed, slope going to be changed at all in any place panels are constructed?
Sorry, I mean, you can answer the question. I would just add that we're going to have another witness who would be better suited to talk to that. Mr. Hughes is the project engineer. He is our next witness.
Okay, well, can I finish a few questions here? So my question is, you guys haven't studied that at all? The next witness can speak to that, but as the project manager here, what is going to happen? If this room right here was the field you're put solar panels on, are you going to go in there and level some spots to put those posts in?
First of all, there will be an erosion control and stormwater management plan. We will apply for the needed permits, and we also have stated that there will be some grading that will be carried out.
Grading for what purpose?
There is, I'm trying to answer the question here. There will be grading required to install roads. There will be grading required to meet the tolerances of the solar panels and the trackers. And there will be grading required to install the utility switchyard and the utility substation and the project substation.
So, just so I understand this correctly, where solar panels are going to be installed, a post with panels on, there's going to be grading in those areas?
In some areas.
Okay. So if you look at the ordinance is written to maintain the character of the township to be predominantly agricultural use. And that's what you said you plan to do after the project's over. It took thousands of years for this soil structure to form, to grow crops on, okay? The first horizon is called the O horizon for organic matter. That can be altered and changed over time. The next horizon is the A horizon, where the roots grow. When you destroy that property, and if we tear this school down, you're not going to plant crops in this room anymore, because there's no soil structure to grow crops on, or water retention or anything. So when you destroy the property by grading everything, how are you going to turn it back to agricultural use?
The object, I guess I object to the form of the question. It's argumentative, speculative. It's outside the scope of his.
Well, it's very vague to everybody what's going to happen to the property. We can't get any clear answers on that. I mean, I can wait for the next witness if you like.
We have discussed the fact that we will be planting with native seeds the entire area, so there will be additional organic matter on the property during the project. We have also discussed that before, as part of the construction process, we will first remove that organic matter, store it, protect it, and then reapply it after the grading activities have finished. And during the commissioning, we also will be carrying out the same practice, which is after the removal of the facilities, then the soils will be returned. They will be reapplied, as well as the organic soils, and then decompacting will occur where necessary.
Sounds good.
Thank you.
Okay. Any other questions from the board? Okay, is there a redirect?
Yeah, I just, Mr. Larios, to go back to the proposed condition of working with neighbors to provide additional screening. It's Leeward's position, well, it's Leeward's representation through its case that it complies with the zoning ordinance.
Correct.
With the buffer yard requirements.
Correct.
With the glare requirements.
Yes.
So that there is no requirement to provide neighbors with additional screening.
That is correct.
And this is just an offer, should anybody want to have discussions with Leeward about installing additional buffering and screening, even though it's not required.
That is correct.
That's something Leeward is willing to have discussion with.
Yes, sir.
Mr. Cluck, any recross?
Just to be clear, if citizens present as my clients or unrepresented parties continue to oppose the project, but if the board in their wisdom decides to approve the project, will you still work with my clients and the unrepresented parties if they still wish to have additional buffering, preferably for more than $5,000, or will you cut them off because they oppose the project?
We will not cut them off because they oppose the project.
Thank you. That's all I have.
Mrs. Palina?
Nothing, thank you.
Mr. Hartman?
I'll wait for the next one.
No questions. Mr. Yao?
No.
Mr. Ballfazer?
No questions.
Mrs. Ballfazer?
This one, since you made a statement of, removing the dirt and storing, could that dirt, just as a thought, but could that dirt be used like as a berm along the road? Rather than taking that soil, moving it wherever, could you use that soil and move it against, like have a berm along the road, and then shrubs and trees can be planted on top of that to give more of a barrier?
No, ma'am. What I discussed was the manner in which topsoil will be handled. Topsoil has importance to farm practices, and so what I just discussed was that one of the first steps of the project would be to, in areas that will be disturbed, to remove that topsoil, separate it, store it separately, maintain it, and then reapply it after land disturbance has finished.
So you're returning it back to, after you put your solar panels
We're
on?
reapplying it back to the area as well.
Thank you. Ms. Fowler, Mr. Fowler?
Yeah, I just had one question. You said that you would take the topsoil off, remove it to store it somewhere and protect it and then return it. Where would you be taking the topsoil to?
It'll remain on site.
Okay, that's all I had.
Mr. Fowler?
I don't have any questions.
Thank you. All right, this witness may step down. I'm going to call your next witness.
Could we take just a couple-minute break just to discuss witness availability? I don't know if you wanted to get started with Mr. Hughes. I didn't anticipate the question going this long, so.
Okay, why don't we take a 5-minute break? If any pro se parties can come forward, I want to just discuss scheduling on the next hearing.
Yes, please, thank you.
You have a meeting for that?
No.